Hey everybody, welcome back to the Law and Crime Network. I'm Michael Bryant with you for the afternoon session here. We are right in the middle of the JohnChuck closing arguments. Remember, his defense for killing his little girl is insanity. Let's go into the courtroom. This is a continuation of the defense closing argument. Roger Foley, defense attorney, is with me. He's in Florida. Roger, welcome. Thanks for joining me this afternoon.
Thank you.
So let me ask you, this case is all about the insanity defense. There is so much going on, though. So many events from this defendant's past, as far back as 5 years old. He has a mental disease or defect, according to most experts, and I'll circle back to that on another question I have for you. By most experts, that's what he's got. That takes care of one of the prongs necessary for the insanity defense. But the big issue has been, did he know what he was doing was wrong? How do you focus in on those elements to get it to the jury's, get them to believe that element?
I think that the history, Mike, the fact that he's been having ongoing issues for years now, this isn't a manufactured defense that his team, his legal team, has put together. This is something that's been happening for years, where he's been seeing a doctor. He's had psychosis. He's had delusions. Whether he was seeing a psychiatrist for delusions or bipolar disorder, there's been clear indications that he's had delusions, obviously to a new height in this, this situation where it caused the death of his daughter. But I think that this is a very solid defense. I think this is a person, at least from what I've seen, who has clear mental illness. And I think an insanity defense is right on point here.
And as you know, it is used so rarely. It's just, we hear about it more often than it's used. It's used in about 1% of all cases. And in 99% of those cases, it fails. So if, in fact, it is successful here, it will be quite a job for the defense attorneys. Now, I had mentioned most of the experts kind of caved in on the disease or defect portion of the test for insanity. There was such history. There's been so much diagnosis of bipolar, of psychosis, of delusions, all of these things. Then along comes another rebuttal expert. This was the prosecution's expert, Dr. Lazarov, I think her name is. She said, among other things, he has no mental disease or defect. She didn't even really worry so much about the second portion of the test. She said he doesn't have a disease or defect. There we see her when she was testifying. I think the defense did a tremendous job in this closing to focus in on her aberrant opinion, because it's like, she's in the World Series of Poker and she's pushing all her chips in, saying, I'm not going to worry about whether or not he knew what was right or wrong at the time. He has no mental disease or defect. Therefore, insanity doesn't work. What do you think?
It bothers me that you have an expert that is so, like you said, all chips in here. There's clearly, you don't need to be a psychiatrist. You don't need a medical degree to see that this gentleman suffers from mental illness. It's just whether or not he had a rationale at the time of the incident where he could determine right from wrong. So I don't know where she's getting that. I think it's going to be hard for anyone to buy in on what she's saying. But the scary thing is a jury might. A jury might listen to her and say, you know what, I like the way she said it. I don't think I think he was just evil. And that's scary.
Yeah, and her testimony was chopped up dramatically because it was subject to so many arguments out of the presence of the jury. The subject she could talk about, the basis of her opinion, it was back and forth until ultimately she was able to give the opinions that she did, which, as I said, included some belief that he has no mental defect or disease. Real quickly here, Roger, let me ask you, as the jury is starting to, they got to feel some anticipation now. After all this time, we're going to get the case. And this is a case that's been put on by the defense to almost twice the amount of time as the prosecution's case. That's rare. Have you come up against that before?
Where the defense is longer? No, but I haven't had an insanity case either. Like you said before, it's 1%, and out of the 1%, 99% of those fail. So it's not a defense that's used. But again, this is the case. So I'm really curious to see, what the outcome is and what the jury thinks of it.
Yeah. So
but clearly they don't know those facts. They don't know that it's 1 in 99%. Right?
Of course. It's one case to them. That's all that matters, and that's the way it should be. Well, we're going to get back into that case with JohnJonchuck, and the closing arguments are still underway, we believe. They're on a break right now. Prosecution will come back for a rebuttal to that. And don't forget, we're in verdict watch in the case of the guy who stabbed the basketball player. You remember? The self-defense argument. They've been deliberating about 2 hours. So we're watching that. We're verdict watch there. We're back in JohnChuck right after this. So this is the prosecution's rebuttal argument in JohnChuck out of Florida. And it's very important to point out what he is telling this jury, and that is what is the burden of proof that the defense has to carry to prove insanity. It is that clear and convincing evidence. Roger Foley, in your experience, do jurors understand that fine difference between clear and convincing and reasonable doubt?
You have to explain it to them, and that's precisely why the prosecutor is doing that. Because we hear these terms all the time, whether you're an attorney in the legal field or not, you hear the terms on TV shows, but people get lost in the nuances of the definitions. They are difficult. Our own Supreme Court has had difficulties explaining some of these things. So he's doing a good job at explaining.
Yeah, I think it's also the title of a Grisham book somewhere, Clear and Convincing Evidence. Okay, we're going to take a quick break. We'll go back into that courtroom with more closings in the JohnJonchuck case. Stay with us. There is Douglas Ellis. He is passionately bringing about the rebuttal argument for the prosecution in Florida versus JohnJonchuck. Remember the prosecution, because it is their burden for the case to, they get to argue once and then the wrap-up argument. The defense in this case, though, has really the most important burden, and that is proving that their client was indeed insane at the time that he dropped Phoebe from that bridge. With me is Roger Foley out of Florida, not too far away from where this is happening, a little bit further down the coast. Roger, one of the things he's focusing on here is the motive, which we know is not important in terms of proof, but he's trying to give the jury some reason to think that there was some other reason than insanity to drop his child off the bridge. And he itemizes problems with drugs, problems with money, didn't really have a home, problems with his dad, all kinds of things like that. How do you think he's doing with that kind of rebuttal to the defense argument?
Personally, I think that it's actually helping the defense a little bit. He's talking about problems with money. He's talking about the Bible and wanting to get the Bible from his dad, and he's talking about thousands of things on his mind, and how he's he's going from place to place. He has no stability. All of those things signal mental health issues. But now, can the jury take it a step further? Can they say that it's not just mental health, it's not just bipolar, it's not just mood swings, but that he was actually insane?
How do you feel about the defense objecting and asking for sidebars during a closing argument?
Well, I'm not a big fan of that unless there's something that just jumps out, that just egregious error. My personal style is I tend to let the prosecutor do their thing, because I'm going to have my opportunity to speak. Obviously, he's not going to have another opportunity to speak, but the prosecutor was doing this in the first half of their closing as well.
Yeah, and unlike the opening statements where you have to stick to what the facts will be shown in court, it's an argument. So you can take all the facts, draw reasonable inferences, you just can't misstate the evidence. So sometimes the jury will hold that against an attorney who keeps objecting. Hey, the guy's just trying to do his argument, leave him alone for a minute. We're going to get back into that argument and that rebuttal with the prosecution in JohnChuck when we come right back.